Welcome back. Will Worsham joins us now for this week's Speaking Legal Discussion. Good to see you again.
Hey, glad to be here.
We got a good question for you today.
You ready for this?
Yeah, I am. This is a fun one.
Here we go. I was asked to shoot some photographs for an educational textbook. I traveled out of state at my own expense, and there was no written agreement, only a verbal one regarding the purpose of the photos for photo credit within the textbook. I shot hundreds of photos using equipment provided for me. Shortly after returning home and after exchanging the photos and having finished JPEGs available to the institution where the photos were taken, I was told I was no longer part of the project. The work I had done would not be needed. I emailed the institution confirming that my photographs not be used since they had access to them and I was no longer part of the project. But the people in charge claim they own the photos and can use them as they wish. Who is right?
That's kind of a long, involved question.
Yeah, but there's a lot of good stuff in there.
Yeah, so where do we start?
Well, first of all, let's just start with some basic legal principles. A verbal contract is worth every penny of the paper it's written on. Okay?
Mm-hmm.
Yeah.
So let's start with an understanding that our first mistake, if I can put it that way, is we didn't put down in writing. Okay. And a lot of times I'll counsel people, it's not that we want to write this down because we want a contract that we want to go to court that we want to sue over, but we want one document that 2 weeks, 2 months, 2 years later, we can both sit down and look at it and go, oh, well, yeah, that's what we agreed to.
Mm-hmm.
And so writing things down is extremely important.
It seems so simple.
It does, but sometimes we just want to shake hands and do a deal,
Sure.
and that's great, and that's all fine. Now, so let's just back up and let's deal with the question here. So there's a couple of issues. First of all, I think that the person who asked the question rightly raises the issue of who owned the equipment. That's a factor. Whose equipment was this that was being used? Who was paying the expenses? Who was doing those things?
Yeah, so someone else provided the equipment, but this person actually snapped the photo.
Right, and that's the key piece of copyright law in the United States at this point is the photo belongs to the person that takes the picture, not the person that owns the equipment, not even the person that is the subject of the photo. Mm-hmm. So if I'm taking your picture, I own the picture of you even though you're in the photo.
So if I hand you my phone and you take a selfie of the three of us, you own that photo.
I own that photo because I'm the one that snapped the shutter. That's current copyright law in the United States. Now that's all modifiable by contract, and that's why we often go back to, let's write this down, because there's a doctrine called work for hire, which says I'm hiring you to take pictures on my behalf, and I'm going to own the photos that you take. And because we have a written agreement that we've agreed to that says that, then I own the photos even though you're the photographer.
But now that is going to work two ways, because this institution is saying, yeah, but we own them.
Well, I think the institution...
that's kind of an acknowledgement of you took them, but we own them.
Yeah, I think based on clearly the fact scenario described here, the institution is wrong. They should have had a written contract that said this is a work for hire job. We're hiring you to take these pictures that we will own. We're providing the equipment. But since they didn't do that, the default is, copyright law as it exists, says the photographer, the person that snaps the shutter, owns the photo. Now I want to back up just a second because I talked about if I take a picture of you.
Yeah.
Now that doesn't mean I have a total license to use that picture of you any way that I want.
Okay. Right.
You still have publicity rights in your own image. And so it's not like I can take pictures of people and then use them in any way that I want.
Right.
If you're in public, you have the whole paparazzi issue. If you're in public where anybody can take your picture, then you're giving up some of those privacy rights. But if there's a studio session or something like that, then I may own the photo, and I may have given you a license to use them however you want, but I retain the ownership of that. You can't use them outside of the license I give you, but I can't use them in a way that you would not necessarily approve of if I'm presenting you in what would be known as a false light.
Right. That's a whole different thing, too. Very interesting, though. Be careful who you hand your camera to.
Yeah,
right?
Because there was something happened within the last few years where PETA sued, and a monkey who grabbed a phone and took a picture, the picture belonged to the monkey.
To the monkey.
Yeah.
If a monkey can own There's probably a children's book there. Can a monkey own
Can a
it?
monkey? Yeah, there is a children's
But
book
as they
there,
said,
yeah.
yeah, but it's still a monkey.
A wildlife
not.
camera, the selfie was a dandy of a picture, I will say
Now,
that.
if
yeah.
you have a legal question for Will, you can email him at wworsham@color10.com, and he will answer your question right on the show.
Thanks very much.
Thanks, Will.
Thank you.
All right, up next it is Dollars and Cents with Bruce Porter. Ozarks Live will be right back.